Okay, so today we're going to be talking about the rights of the accused, and this is in chapter 20.3. One of the first things we want to talk about is the writ of habeas corpus. This is also called the writ of liberty. This is intended to prevent unjust arrest or imprisonment. So this is a court order directed to an officer, the policeman, holding a prisoner that commands that the prisoner be brought before a court, and then the officer has to show cause and explain good reason why the prisoner should not be released from jail. Now, a second term is called a bill of attainder. This is an act that provides for the punishment of a person without a court trial. Now, these bills are very rare. One case that did fall under this is the United States versus Brown. And in this case, it was made a federal crime for a member of the Communist Party to be an officer of a labor union in the United States. Now, there's also what we call ex post facto laws. So an ex post facto law is a law that is applied to an act committed before the passage of a law. So let's say a state makes a law that says it is illegal to sell marijuana. Well, if you were selling marijuana before that law came into effect, then you can't charge somebody with that. Okay, so again, it makes it a crime to sell something before it's occurred. Okay, that's ex post facto laws. All right. Now, retroactive civil laws are not forbidden. So what this means is that if your local state raises your income taxes in November, that means that they can charge you this new rate for any funds, any amount of money that you have earned throughout the whole year, not just starting in November. Okay? So, the rights of the accused. Let's talk about a couple of things. First, there is an arrest. So, an officer has to have a warrant or act on probable cause, and you cannot have an unreasonable search or a seizure. The second is interrogation. The accused must be informed of their right of counsel, the right to an attorney, and the right to remain silent. And no third-degree methods of coercion for confession are allowed. That means beating a confession out of somebody. The third thing is grand jury proceedings. The grand jury weighs evidence that is provided by the prosecutor, and after listening to it, the grand jury may accuse somebody of a crime, okay, charge them of a crime, and bail that is set for the accused person cannot be excessive. A trial is the fourth part. There must be a public trial by an impartial jury, and it has to occur within 100 days of you being arrested. The accused may request a change of venue, meaning move it to another location. Assistance of counsel, having an attorney, is guaranteed. You cannot self-incriminate, and there's no such, you cannot have double jeopardy. We're going to talk about those in just a minute. Punishment, okay, is the fifth thing. You can't have an excessive fine, and you cannot use cruel or unusual punishment. And the last one is an appeal, which means that both sides may appeal a verdict against it. So let's talk about a couple of key terms here. Now, a grand jury. This is a formal device by which a person can be accused of a serious crime. This is any offense for which the punishment is death or imprisonment. The second is an indictment. This is a formal complaint that the prosecutor lays out before a grand jury, and it charges the accused of one or more crimes. The next is double jeopardy. This means that once a person has been tried for a crime, he cannot be tried again for that same crime. You're found innocent, okay? 3 months later, they find a key piece of evidence that would have made you guilty. They can't charge you again. And then the last one is self-incrimination. No person can be compelled to be a witness against themselves. And the burden of proof is always on the prosecution. And the defense does not have to prove that they are innocent. The prosecution has to prove that you are guilty. You are also guaranteed the right to a speedy and a public trial. Again, a speedy trial is meant to ensure that the government tries a person that is accused of a crime within a reasonable amount of time and with undue delay. And again, the courts have said that reasonable amount of time is that the trial must occur within 100 days of being arrested. You also have the right to a public trial, okay? The U.S. Constitution provides defendants in criminal cases with the right to a public trial. Witnesses, okay, also have to be brought that are less likely to lie in a public setting. This makes a public trial the potential that a witness is probably going to tell the truth. Again, because if you lie on a witness stand, you can then go to jail. Some trials are televised, okay? So this again is part of a public trial. Not all of them are. But if it is a televised trial, steps have to be taken to make sure that there is not too much publicity, and that it also has to be able to protect the rights of the person that is being accused. Somebody who is convicted of a crime, who is accused of a crime, also has the right to a trial by jury. So the Sixth Amendment to the Constitution says that a person accused of a federal crime must be tried by a, quote, impartial jury. The members of the jury must come from the state and the district where the crime was said to have been committed. The accused can ask for a change of venue, we talked about this a little bit ago, on the grounds that the people at the location where the crime was committed are so prejudiced against you that an impartial jury cannot be found. Now, you also can ask to, you have the right to waive a jury trial, meaning that you want to have the judge decide the outcome of the trial. This is what they call a bench trial. So the judge is the only one that hears it, and then he or she will make a ruling on it. And the last one that we're going to talk about today is the right to an adequate defense. So every person that is accused of a crime has a right to the best possible defense that circumstances will allow. An attorney must be furnished to anyone who cannot afford one. And the Sixth Amendment says that a defendant has the right to, number one, to be informed of the nature of the accusation against him. Number two, to be confronted by the witnesses against him and allowed to be able to question that witness in open court. Number three, to be able to have witnesses called that will be testifying in his favor. And fourth, to have assistance of counsel in his defense. Now, all of these guarantees are intended to prevent cards from being stacked in favor of the prosecution against somebody who is accused. Again, these are some of your rights. Hopefully, you're never going to have to go through this. See you tomorrow.